And Carly, this certainly is something this mother would like to forget. Tonight I talked to her and she walked us through those terrifying moments where she thought she was going to lose her child.
Did someone try to take you from mommy?
Yeah.
Caroline Miller's trip to Walmart last week with her two children, Nova and Jude, started off pretty normal.
Nova, of course, wanted to ride the little motorized cart, so that's what we got on, and it actually ended up breaking down.
She says a man then walked over to her in one of the aisles.
So that's when the man came up to me and asked, "Do you know where the Tylenol is?" And I was like, "Oh, it's over there." And as soon as I did that, that's when he just picked him up out of my arms.
Miller says she then played a terrifying game of tug of war for about 10 seconds, which felt like an eternity.
And then he just stared at me and then goes, "Oh, I just wanted to get him out of your lap so you could get up and help me."
Police say it was this man, 56-year-old Mahendra Patel. Ackworth police tracked him down and arrested him after he left the Walmart. 2-year-old Jude was not hurt, and his sister was unharmed as well, something Miller is grateful for today.
Repetitive of what is already provided in the state's motion, which was filed this morning. The state is making a motion pursuant to 17.8.3 of the official code of Georgia for an entry of null pros as to the following: the district attorney's office for the Cobb Judicial Circuit and Mr. Patel, along with his counsel, Caroline Miller, on her own behalf and on behalf of the minor child, consistent with her election under 1717.1 at SEC, met to discuss their respective views of the above captioned case. That was done on Monday of this week. That election was done after a thorough review of all available facts and circumstances, evaluation of the best interests of the community and goals of the criminal justice system. After both that review and the parties' discussion of their respective positions, the state is satisfied at this point that the ends of justice have been met, and we would move for an entry of null pros.
Merchant.
We have no objection, Judge. Thank you.
All right. I believe it's in the court's discretion, and obviously that's fine with me, knowing what I've seen in the matter. I appreciate the state looking into it. You've complied with the Victims Notification Act by speaking with the alleged victim in the case.
Yes.
And I'm satisfied. If you present the null pros, I will sign it.
Thank you, Judge.
Null pros has been entered in the Patel case.
Thank you, Judge.
Thank you, everyone. That'll complete the hearing on Patel.
So that was one long saga, all because Caroline Miller claimed that Mahendra Patel, tried to tug of war, grabbed her children for 10 seconds. It was terrifying. Had her kid ready to say, "Did a man try to take you?" Yeah. So what happened this week, and I heard this from brother counsel because his brother is one of the attorneys representing Mahendra Patel, is we now have a federal civil lawsuit filed. So we are going to read this complaint. I've been looking for the complaint and finally saw it last night. So I've been waiting for this morning to get together with you guys. I know a lot of people are also looking for updates on the Edric Foss case. There is no court today in that case. So in case you're looking for that update. Over here we have Mahendra Patel. He's the plaintiff. This is in the Northern District of Georgia. This complaint is being filed against Officer James Evan Wallace, the city of Ackworth, that's where the Walmart was, Sonia Allen, Carolyn Miller, and Temperance Stoddard jointly and severally. So we have plaintiff Mahendra Patel is a resident of Georgia. We need all of this stuff for jurisdiction. They'll go over that in the next section. Defendant Officer James Evan Wallace is a resident of Georgia, was at all pertinent times acting in the course and scope of his capacity as a police officer, and is being sued in his individual capacity. So we're hitting both check marks there. Defendant City of Ackworth is a municipality in the city of Georgia. Defendant Sonia F. Allen is the elected district attorney of the Cobb County District Attorney's Office. And the DA's office, she's a prosecutorial office organized under the laws of Georgia with its balanced principal place of business in Marietta, Georgia. Defendant Allen is being sued in her official capacity as district attorney. Defendant Carolyn Miller is a resident of Georgia and is being sued in her individual capacity. Defendant Temperance Stoddard is an investigator with the Cobb County District Attorney's Office and is a resident of Georgia and was at all pertinent times acting in the course and scope of her capacity, and as such is being sued in her individual capacity. Yes, I'm going to pin one of these. That way everyone knows that there's no court in the Edric Foss case here. So thank you for having something for me to pin. Make it easy. So jurisdiction, I was going to say that this court has subject matter jurisdiction over this action pursuant to 28 U.S.C.S. 1331 because this action arises under the constitutional laws of the United States. This court also has jurisdiction, as this is a civil action to redress the deprivation of rights secured by the Constitution and federal law. This court has supplemental jurisdiction over plaintiff state law claims pursuant to 28 U.S.C. Section 1367. This court has personal jurisdiction over defendant officer James Wallace because he lives in Georgia. This court has personal jurisdiction over the city of Ackworth because it's a municipality in the state of Georgia. This court has personal jurisdiction over Sonia Allen because she's a resident of Georgia, and so on. Carolyn Miller's a resident, and Temperance Stoddard is a resident of Georgia. So we're saying this is the proper venue. So statement of facts, what is Mick saying? He's a 57-year-old retired engineer, a father of two, and a longtime resident of Georgia. At all relevant times, plaintiff owned and operated a real estate business and was active in charitable and community organizations. Prior to the events at issue, plaintiff had no history of violent behavior and posed no threat to public safety. On or about March 18th, 2025, plaintiff went to a Walmart store. We're almost coming up on a year. Plaintiff went to a Walmart store located in Cobb County, Georgia, to purchase over-the-counter medication for his mother. It was like a specific type of timed release gel capsule Tylenols. While inside the store, plaintiff encountered a woman later identified as Carolyn Miller, who was riding an electric mobility cart accompanied by her two young children. And this is not part of the complaint, but she was riding the cart because her kids wanted to ride the cart. Nobody had a mobility issue. In fact, I would say she had a mobility issue because she was driving that thing recklessly through the store and hitting end caps in the store. But anyway, back to the actual complaint. That's just my personal gripe. Plaintiff asked Miss Miller for assistance in locating Tylenol. Miss Miller agreed and directed plaintiff towards the appropriate aisle. As the cart turned into the aisle, it clipped a display. Plaintiff observed that Miss Miller's 2-year-old child appeared to be losing balance and at risk of falling from her lap. Acting instinctively and without any improper intent, plaintiff briefly reached out to steady the child to prevent him from falling. The interaction lasted only a moment. Plaintiff did not attempt to remove the child from Miss Miller's custody, did not pull the child toward himself, and did not use any force. Immediately after the brief exchange, plaintiff walked away, completed his purchase of Tylenol, and exited the store. And he used a debit or credit card. It's not like he was using cash and trying to hide that he was in Walmart trying to take children. The entire incident was captured on Walmart's in-store surveillance cameras. You would think, right? Several days later, on or about March 21st, 2025, defendant Detective James Evan Wallace of the Ackworth Police Department applied for and obtained an arrest warrant for plaintiff, charging him with criminal contempt to commit kidnapping, simple assault, and simple battery. At the time he sought the warrant, defendant Wallace knew or should have known that Walmart maintained surveillance video of the encounter. Rather than reviewing and fairly evaluating the surveillance footage, defendants Wallace and Stoddard relied almost exclusively on Miss Miller's allegations. They don't go get the video and just watch the video. The available video evidence directly contradicted the claim that plaintiff attempted to abduct a child or engaged in any assaultive conduct. Defendants Wallace and Stoddard failed to conduct a reasonable investigation before seeking criminal charges against plaintiff. And remember, when you're trying to get arrest warrants, you've got to sign and swear off on these affidavits. You make a formal representation. On or about March 24th, 2025, while driving on a Georgia highway, plaintiff was stopped by police officers, informed that a warrant had been issued for his arrest, handcuffed, and taken into custody. Plaintiff was transported to the Cobb County Jail where he was detained without bond. And so remember, they put this attempted kidnapping charge, and it's not a bondable offense. So there was a whole issue. Ashley Merchant had to fight to get him a bond hearing and challenge that. So on April 3rd, 2025, the state of Georgia sought and obtained an indictment against plaintiff based primarily on information provided by defendants Wallace and Stoddard. So this is they have a prelim. They had the opportunity. They could have had spoken with Ashley Merchant. They could have looked at the video, but nope. Even though several days passed, they go and they get this indictment. They don't put all the information forward when making that decision, and it keeps him in custody. Defendants knew at the time of the indictment that the surveillance video did not support the allegation made by Ms. Miller, but they did it anyway. Despite possessing exculpatory evidence that undermined probable cause, defendants continued to pursue criminal charges against plaintiff. Plaintiff remained incarcerated at the Cobb County Jail for approximately 47 days without bond. During his detention, plaintiff was deprived of necessary hypertension medication for several days and lost significant weight due to inadequate vegetarian food options. Plaintiff was subjected to threats and intimidation from other detainees and lived in constant fear for his safety. So remember, he's in there, and we have the benefit of knowing what the surveillance video actually shows. We know that Carolyn Miller's claims were contested, but as he's in custody, he has charges for trying to kidnap a child. So do you think he's going to be treated well? Plaintiff's prolonged incarceration caused severe emotional distress, anxiety, humiliation, and psychological trauma. Because plaintiff's wife was out of town caring for her elderly mother and plaintiff's mother did not speak English, plaintiff received no family visits while detained, with the exception of one video call. Plaintiff was unable to manage his real estate business during this period, resulting in lost income and damage to his professional reputation. And yeah, I don't know what type of real estate he does, but if he has like holding costs or he has like vacancies sitting, that's a lot of money to lose in like 1 to 2 months. In early May 2025, plaintiff's defense counsel obtained and presented May 2025. Plaintiff's defense counsel, not the detectives. What do we pay detectives to do? What do we pay investigators to do? They're not the ones that go to the Walmart, the scene of the alleged crime, and look for any evidence whatsoever. If you wanted to prosecute this man and you believed Carolyn Miller, if Carolyn Miller was telling the truth, why would you not go get this Walmart surveillance footage? Like in a parallel universe where somebody was actually kidnapped, like what are we doing? But plaintiff's defense counsel, Ashley Merchant, the Merchant law firm, obtain and present what seems like the obvious thing, the Walmart surveillance footage showing the interaction between plaintiff and Miss Miller. The video demonstrated that there was no tug of war, no assault, and no attempt to abduct a child. After review of the video, a court set bond and plaintiff was released from custody. On August 6, 2025, the criminal charges against plaintiff were formally dismissed. And by the way, I showed a clip from the dismissal, that hearing, but we also watched a bond hearing. That's linked. There's a playlist for all the little videos I put together of this criminal case. Now we have a civil action. But there's the bond hearing linked in there as well. If you didn't watch that bond hearing, it was like an hour, it was almost 2 hours. And the state's arguments to keep this thing going and to deny bond to Mahendra Patel are like the biggest reach I've ever listened to in my life. So if you want to see a prosecutor reaching and watch Ashley Merchant do really good lawyering and advocacy for her client, that's one to watch. That is one to go back and check out. But ultimately, they kept the case going after the judge granted bond. They kept it going, and then finally were like, hey, maybe we would look stupid taking this to trial. So they dismissed the charges. Despite the dismissal of all charges, plaintiff continues to suffer reputational harm due to widespread media coverage of his arrest. As a result of defendant's actions, plaintiff lost business opportunities, was removed from charitable organizations, and endured significant public stigma. So his mugshot's all over, and it's like child kidnapping. Plaintiff incurred substantial legal fees and costs defending himself against criminal charges that lack probable cause. Defendant's actions cause plaintiff to suffer loss of liberty, emotional distress, financial harm, and damage to his reputation. And I think this was a mistake. Because there's a paragraph here kind of just hanging on that says, well, in the store, Plaintiff approached Carolyn Miller, who was sitting in a handicap shopping cart with her 2-year-old son in her lap and her 4-year-old daughter between her feet, and asked her where the Tylenol was. So I think this is just something that got pushed and nobody noticed it hanging out right here. And then they get into claims for relief. So count 1 is malicious prosecution in violation of 42 U.S.C. 1983. So here, civil rights claims. This is against defendants Wallace and Stoddard. Basically, they had the chance, they caused these charges to be pursued against plaintiff without probable cause by providing material false, misleading, and incomplete information, and by disregarding exculpatory surveillance evidence. And in all seriousness, I don't know anybody who, like, why wouldn't we just have that video available? Whether the claims actually happened or not, this video should have been obtained and it should have been provided. It should have been part of the charging decision. Had defendants conducted a reasonable investigation and considered the surveillance video, no reasonable officer would have concluded that probable cause existed. Defendants acted with malice and reckless disregard for plaintiff's constitutional rights. Plaintiff was seized pursuant to legal process, including arrest on a warrant, pretrial detention, and court-ordered conditions. The prosecution terminated in plaintiff's favor on August 6, 2025. As a direct and proximate result, plaintiff suffered, and this is going to repeat in probably all of the claims, but because of all of this, he suffered damages, including his loss of liberty, emotional distress, reputational harm, lost income, damaged his reputation, and incurred legal fees and costs in defending the criminal case. And let's see. Because of that, plaintiff has suffered damages in an amount to be determined at trial. And if this goes to trial, we're absolutely watching. And then plaintiff is entitled to compensatory and punitive damage. And they want the attorney's fees. So then they've got, let's see, the Monell liability for malicious prosecution against the municipality. So this is the city of Ackworth. Let's see. They have policies, practices, or customs that caused or permitted police officers to initiate and pursue criminal prosecutions without probable cause and to disregard exculpatory evidence. So they had the option, they had the capability of preventing this thing from happening or continuing the way it continued. So what did they do wrong? With these policies, practices, or customs, they failed to adequately train and supervise officers regarding their constitutional duty to disclose exculpatory evidence, encouraging or tolerating the preparation of warrant applications based on incomplete, misleading, or false information, failing to require officers to review and preserve readily available exculpatory evidence before seeking warrants or criminal charges, allowing officers to pursue prosecutions despite the absence of probable cause, and failing to discipline officers who engage in such unconstitutional conduct. The need for such training and supervision was obvious, and the city's failure to implement adequate policies amounted to deliberate indifference to the constitutional rights of individuals such as plaintiff. So, because of these policies, practices, or customs, defendants Wallace and Stoddard initiated and continued criminal charges against plaintiff, despite knowing that the available surveillance video and other evidence undermined probable cause. So they're going to say that these actions were taken pursuant to and caused by these policies and indifference of the city of Ackworth, and he was arrested because of it, and all of these damages. Let's see, we've got a class of 1 equal protection violation against defendants Wallace and Stoddard. They say that the defendants treated plaintiff differently from similarly situated individuals. So, you know, you got white woman Carolyn Miller and her kids that seem coached. You know, did a man try to take you? Yeah. And then you have Mr. Patel. So prosecutors who run the Cobb County District Attorney's Office instructed everyone to treat plaintiff differently and to go after him no matter what, even if they knew he was innocent. Defendants prosecuted plaintiff despite the lack of probable cause and the exculpatory nature of the surveillance video. Defendant's decision was based on an arbitrary and irrational classification. Defendant's decision to prosecute plaintiff was not based on any legitimate law enforcement purpose. Defendants knew or should have known that there was no probable cause to arrest or prosecute plaintiff. Defendants singled out plaintiff for prosecution despite knowing he was innocent. Plaintiff was not targeted because of his membership of a suspect class and the differential treatment. Plaintiff suffered damages as a result of the Class of 1 equal protection violation. Plaintiff spent 47 days in jail without bond. He suffered lost wages, emotional distress, mental anguish, and incurred legal fees. Let's see. We've got conspiracy to deprive constitutional rights. That's going to be against all defendants. And this is where we see Carolyn Miller entering the stage because she's the one that makes the false allegations. We've got, let's see. And the prosecution continued because of her allegations because they clearly were not relying on the video. Let's see. Malicious prosecution under Georgia common law. So that's against defendants Wallace, so the officer, the city of Ackworth, and Carolyn Miller. So on March 21st, you have Wallace apply for the arrest warrant that charged him with kidnapping, simple assault, and simple battery. On April 3rd, the state sought an indictment against plaintiff, and the grand jury returned an indictment charging plaintiff with criminal attempt to commit kidnapping, simple assault, and simple battery. Carolyn Miller's the one who made the false accusations that led to this prosecution. Defendants continued to prosecute plaintiff until the charges were dismissed all the way in August 6 of 2025. Defendants initiated and continued the criminal prosecution without probable cause. The Ackworth Police Department incident report states that Carolyn Miller did not lose grasp of her son and pulled him back. So that's a contradiction to what she said in an interview. She said she lost for like 10 seconds that he had her child. The Walmart surveillance video, when viewed in its entirety, made it clear that no crime took place. Despite the lack of probable cause and the exculpatory nature of the surveillance video, defendants continued to prosecute plaintiff. Defendants acted with malice in initiating and continuing the criminal prosecution. On April 3rd, 2025, the same day that plaintiff's defense counsel served a subpoena on the Ackworth Police Department for the Walmart surveillance video, the state filed a motion to quash the subpoena and sought an indictment against plaintiff. So, this is the type of thing I might not have wanted to just go and read this complaint. I might have shared it on X. I might have mentioned it on the lunch break. What are we doing? What are we doing? The very same day. Hey, we want surveillance video. Or like any discovery you have, which we presume you should have collected surveillance video because it's like a public store with cameras. Give that to us. Oh, no, quash that subpoena. Quash that subpoena. And let's go get this indictment. Just crazy, 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 crazy. The state's simultaneous filing of a motion to quash the subpoena and seeking an indictment suggests consciousness of guilt or knowledge that the surveillance video would exonerate plaintiff. And, we got to learn throughout all of this that Carolyn Miller has a history of accusing people, making these accusations. I'd say that one guess is maybe the officer, maybe someone at the DA's office was already familiar with Carolyn Miller's game. So that might have put them on alert, like, hey, something might not be right here, but here we go anyway, I guess. The state did not call Detective Wallace to testify to the grand jury, instead calling an employee of the district attorney's office to testify. Prosecutors who run the Cobb County District Attorney's Office instructed everyone to treat plaintiff differently and to go after him no matter what, even if they knew he was innocent. Carolyn Miller was a known liar with no credibility, yet defendants relied on her false allegations to prosecute plaintiff. The criminal prosecution terminated in plaintiff's favor. On August 6th, the charges were dismissed. Plaintiff suffered damages as a result of the malicious prosecution. 47 days in jail without bond. We've got the lost wages, the distress, the mental anguish, damage to the reputation, the legal fees, and then as a direct and proximate result of defendant's malicious prosecution, plaintiff has suffered damage in an amount to be determined at trial. Wherefore, plaintiff respectfully and I think the parties should settle, but there's several parties here, so I wonder, like, the municipalities, the officers, maybe this would be good for PR to just get rid of it. But what is Carolyn Miller gonna do? Plaintiff respectfully requests that this court award compensatory damages against all defendants in an amount to be determined at trial. Award compensatory damages against all defendants in an amount to be... All right, I think we're repeating there. Yeah, okay. And then punitive damages, there we go, against all defendants in an amount to be determined at trial. Award reasonable attorney's fees and costs, and then grant such other relief as the court deems just and proper. Plaintiff demands a trial by jury on all issues so triable. February 9th, we've got David Michelli here, who is holding the Georgia bar and applying for the Pro Hoc Vice and already doing some interviews, doing great work here for Mr. Patel is Alex Strauss and Solomon Radner. So there we go. That is the complaint, you guys. That is the complaint. Let's see. I'm going to work a little backwards. Brittany says, hell no, I'd take this all the way and make sure the world sees what happened here. Heck yeah, I'm glad that they... And I know Mick had mentioned this in some of the interviews around August when the charges were dropped. Like, he wanted to fight. Like, he didn't want this to just be something that got swept under the rug. And I think that's an admirable thing to do. I think it's the right thing to do as a personal choice, but I think it's also a really good thing to do for the pressure it would put on anybody involved on the side of pushing this forward. Autodoc says Mr. Patel really isn't interested in settling for an undisclosed amount, I'm pretty sure. Well, but that doesn't mean that they'll try to offer. And I believe, I'm not sure about Georgia specifically, but some other municipalities, I mean, they have to have approval for settlements. So sometimes even if a settlement isn't reached, if a municipality wants to propose a settlement, you know, there might be news coverage on it. So we would get to see their attempts to try to brush this under the rug. And again, a settlement where they admit to wrongdoing, I mean, that's different than a settlement where, hey, we don't admit to wrongdoing, but we'll give you some money. So we've got, let's see. And don't forget, guys, there is a playlist if you want to go back and look at the bond hearing. Great arguments from Ashley Merchant. Yeah, I would say the story definitely got bigger after he was arrested. And you know what's kind of weird is for me, my gut reaction to the video of Carolyn Miller was like, there's just something off about her demeanor in the video she chose to sit down and do with the news agency. So it's like, I don't know, does law enforcement not have that gut feeling? Like, I feel like it's their job, whether they have a gut feeling or not, to go and get surveillance video and check it out. But especially if she's smiling while recounting this and seemingly coaching her children to say, yeah, a man tried to kidnap me, yeah. Like, do people that get hired as detectives in these Georgia counties have any intuition? Like, I don't know, let alone integrity. Yeah, Martinez says 47 days is a lot for something there's video of. And remember, I mean, maybe for simple battery, rather than like the attempted kidnapping, he would have gotten an appearance ticket and not been in custody at all. That's a little bit of a different situation. Still not a good charge, but at least it would have kept him in custody. But they put on that attempted kidnapping and fought his release. So Kiana's happy he's suing. Me too, me too. Hey, Sabata. Hey, Sabata. Yeah, Georgia cops seem to hate surveillance footage. Do you know how McDonald's surveillance video works? Let's see. We've got, yes, also shout out to Queen Cruz. So Ahmad Cruz's wife, don't know the details, but I believe that court in the Edric Foss case is canceled today because of, we'd heard that Attorney Cruz's wife had to go to the hospital. So really, really scary to have something like that happen, period, but also in the middle of trial. And Cruz argued a motion for a directed verdict, was representing his client, and then got to go get with his wife. I can only imagine having to have both things on your shoulders. So Tara says, I forgot he was in custody. Yep, makes the case even more insane. Melanie, always good to see you, Melanie, says they had the footage and wouldn't give it to his attorney. They tried to gag the attorney before they would hand over the video. That's right. That's right. Sweetie Pie's like, everybody knows they have cameras everywhere. Yeah, very good, hardworking cops. Imagine if there was an actual child abduction. Child is gone. God forbid, in the words of Brian Steele. And we find out that law enforcement and then the detectives, the investigators at the district attorney's office don't go and obtain surveillance footage. Like, it doesn't make sense. Eric says, had he been detained, arrested in the moment, I think it would have been proper. They had plenty of time to review the cameras and get facts and went forward anyways. So there's actually a case that I talked about like 2 weeks ago now, maybe 3. Melissa Sims. So she, live-in boyfriend, they break up, they're still living together. There's tension in the house. The ex-boyfriend seems to make this claim of battery. So he claims that she hits him, and she's like, no, check under my nails. Like, the scratches, he did them to himself. Like, look the way that they're on his back going upwards. Like, test my nails, test under my nails. Like, they're clean. And then with that claim, the court's like, all right, well, here's a battery charge for you. You're going to have restrictions. Don't send messages to the victim, the ex-boyfriend who made the claims. The ex ends up making fake text messages and tells law enforcement that Melissa Sims, she's not supposed to contact me, and here she is texting me. And she ends up getting detained. She's held overnight for a few days. And my thought there is like, all right, well, I don't know. I don't see how practically the cops could thoroughly vet the messages right then and there. But and it for the issue of safety, right? I think they'd be at fault if they didn't take action and something actually ended up happening physically after that, right? If they did nothing, you don't know. You got to take the precaution. But between that initial reaction where vetting the information isn't practical and the few days where you have the chance to maybe just get some phone records, maybe look at the physical device and see if it's actually just a screenshot or if it was sent, like there's ways that they could have realized that, and they didn't. They took her to trial. They took her to trial anyway. So it's one of those things where, yeah, like maybe right away you've got to make a tough decision in the moment when you can't know everything right away. But why aren't you getting the footage? Just why aren't you getting the footage? So, and Autodoc says, the cops saw all the video the same day. I believe we ended up hearing something about that, where they were at least in the Walmart, and the Walmart employees offered, and I believe they said no. But I'm pretty sure I remember hearing something about that. It might have been during the bond hearing. So it's been a little bit. It's been like 8 months. We've got Mama Claire saying, I could not believe it when I first saw his story on Brother Counsel. Yeah, it was really cool. He was like, oh, my brother. So cool to see Solomon Radner handling this one. Yeah, I think it was the bond hearing as well. Yeah, Autodoc said he only got a bond hearing because of public pressure, and I'm glad maybe I can find the transcript to the little clip real quick and we can watch it. The judge even said something to the effect of like, I'm not supposed to pay attention to what goes on outside the courtroom, but, and he's like, I can't help what I know. And my read on that is he was not happy with the state's decision to be doing what they were doing. Let's see, bond hearing. Mahendra Patel. All right. Let me cue up a little piece of it. Let's see. Did it say media? Oh, even worse. Let's watch this prosecutor. The first result I got is, we do have safety concerns because of all the media. Let's watch this guy make this argument.
For the court that are somewhat, they corroborate what Mama said, that she was scared by a man that was trying to grab a 2-year-old child from her lap, and he admitted that his conduct had placed her in that apprehension as well. So We do have safety concerns because of all the media that has been generated by this case, largely because of things, candidly, that the defense has put out, which is why.
What did the defense put out? I'm going to get mad watching this all over again, as if I haven't already watched it, as if it hasn't been years, as if this judge was not buying this. I would quit my job if my boss wanted me to go make this argument that this guy's making here. What did the defense put out that was making things a security issue?
We filed the motion for the protective order. Our preference is not to try these types of cases in the media, but instead to have full, fair, transparent court hearings to deal with these things. The fact of the matter is that this mother was with her 2 kids minding her own business, and this man, Mr. Patel, made a decision to grab a 2-year-old child from her lap at night in a Walmart. Even the witness who was interviewed by the police on the next aisle said that he was essentially unnerved by what he had seen and wanted to share that.
Why is there always a qualifier? Essentially.
With the police as well. There are 2 separate 911 calls, one placed by the victim's mother, one by a Walmart employee. Of course, you've now seen some of the video. I've told you about the Be on the Lookout that was issued the night of, as they tried to identify who this stranger was to this woman who tried to grab her kid from her lap. And fortunately, thanks to our advances in technology, I'm sure the court's aware of it, Flock, for our purpose of our record, as a license plate reader, we're able to identify the defendant.
So this man is making the argument, oh, all of this happened, but the only thing that the defense released was the surveillance footage. So if there's surveillance footage, if you're standing 10 toes down on what happened at that Walmart, but you're also saying that the defense is doing something wrong and causing a security concern on that same thing you're pretending to stand 10 toes down on, like, how do we make that make sense? Anyway, I was looking for the judge. Let me see. What was the judge saying? Hold on. He said something somewhere in this hearing that was like, definitely him raising his eyebrow. I think it was here. All right.
Look at all the people here. I mean, he's definitely not a flight risk. We've tried to show you that. He's got significant ties to the community, significant property in the community, and he's just not a risk. So we just ask that you grant him bond. Thank you, Judge.
Thank you.
Well, first of all, let me just comment on the amount of media attention and internet attention, social media. It's always been part of my duty, anytime I have a case similar to this, that I do not watch local news. If I'm in the Marietta Daily Journal and I see anything that leads me to believe this might be my case, I don't read it. I don't look at anything on social media, but I must say that it's impossible to not see that it's out there, and it's been very difficult to not look at anything, but I've done my very best. So I feel like I'm going into this on an even keel with the state and the defense. I'm going to grant this man a bond. He's entitled to a bond. Based upon even the allegations of the state, his history here, he owns property, you said, in the Harrison district. He's educated, he's retired, manages properties, plural, apparently. He's married, he's in the Kiwanis Club. I mean, he's got all that he needs to show me that he's a member of our community and that he has ties to the community. I don't blame the state from pointing out, and you did it yourself, Ms. Merchant, that he has some convictions. He doesn't have any type of conviction that bothers me in terms of any type of violent behavior or anything of that nature. I don't see any haven't heard any evidence of any arrests for any type of sexual, certainly child sexual type arrests. I'm not worried about that. I don't believe he poses a risk to the community. The evidence from the video, and I won't comment on what I think the video really shows as far as guilt or innocence. It's not.
This is the part. This is the part.
And I won't comment on what I think the video really shows as far as guilt or innocence. It's not my job today. But the fact.
When we were watching this live, oh man, just like imagine being the state sitting there while the judge says that. I get that his words are not saying one way or another, but after he just started, I'm going to grant this man a bond. If you skip all the context in between and immediately say, I'm not going to comment on what I think the video shows of guilt or innocence, because that's not what we're here for today, it reads as, state, do you have eyes? Like, so there's a little throwback, you guys. This was the bond hearing. We watched a little bit of the hearing from August where the state announced the null pros and the judge accepted, just to give a kind of like full circle and why we have this civil suit coming forward. So I want to see some consequences. I want to see some accountability. I want to see some pressure. Got several people named here. So if you missed it at the beginning, it's the officer. It's Officer Wallace. It's the city of Ackworth as a municipality. It's Sonia Allen in her capacity as District Attorney of Cobb County, Carolyn Miller, and Temperance Stoddard, who is an investigator with the DA's office. So pretty exciting to see where this goes. And yes, let me find I know there's going to be, there we go. Brother Counsel's brother Solomon is the attorney in the case now. So that's always going to be fun to see. Bailey says keep going. Okay, we can watch the last little bit.
Facts do show me that he hung around, and I don't find that he's a flight risk based upon what I saw in the video and what was just, I'll receive it as a proffer from counsel about him hanging around. I'm not concerned that the police didn't get him the same day because he's presumed innocent, and innocent people don't worry about the police coming to get him. So that didn't bother me. I'll grant a $10,000 bond. That was the number you gave me.
Thank you, Judge.
I don't have any problem with it. He can make it any way he wants. It doesn't have to be a cash bond. As far as conditions, let me hear from you, Mr. Evans, as to any special conditions that, I would always put in there, no drugs and alcohol, not because of the allegations that you've made, but that's every bond I do. And although I'm not a magistrate, I don't grant that many bonds because of reasons you know about. No drugs and alcohol, no contact with the alleged victim or any member of her family. What else do you want?
You've nailed almost all of them, Judge. No contact with the victim, the family, that Walmart in particular, I would say.
Don't go to that Walmart.
Sure. Drug, alcohol evaluation, treatment, and screens.
I would not want to go to that Walmart. I would be so icked out. And I know it's not like the building's fault, but like, I don't know. You guys know that feeling when you just get an ick about a place. Like, how did this even happen? I'm just driving home one night and I get pulled over and they tell me I'm under arrest for kidnapping, attempted kidnapping. I would not want to go back to, at least for a while, the place of grief.
So
I don't have enough to make me do that.
Okay.
Yeah, no. Pretty sure he doesn't want to be anywhere near her.
If he picks up another problem with alcohol, then he probably will be back where he is right now.
Sure.
So.
And then the follow-up to that, I think you've already articulated no alcohol or drugs that are not lawfully prescribed to him.
Right.
Yes, sir.
Do you object to any of those conditions?
No, Judge, not at all. I'm not sure, this wasn't mentioned, but I just wanted to bring it up in advance. He has a trip in August that's already been paid for. We just want to make sure that he can go on that trip because it was a trip that was originally bought and paid for, and then his father died and it had to be moved. And it's with both of his children, extended family. It's an international trip. And so that is very significant to him.
Well,
I always laugh when Happily Angry Lawyer calls John Mr. Ashley Merchant.
In August.
he's on probation right now?
No.
Power
He's not
couple.
on probation
He's not,
right
no.
now. I got people in front of me that live in New York, and, they certainly can go to New York.
Thank you.
And if I thought he was a risk, I wouldn't let him out of jail.
Thank you, Judge.
If you want me to put something in writing, then I'm happy to.
And I appreciate that. I don't think it'll be an issue with that. Thank you.
All right. Then why don't we do this? Madam Clerk, if you'll get the standard order, work with counsel, get both of them to look at it. Mr. Evans can consent as to form only, and then bring it back to me in chamber so
I
that
think
I
that
can
was this
review
day,
it.
Sunshine.
And then I will come back in the courtroom and go
I think they
over
cheer
them
at the end.
and get the man's signature, and that'll take care of it.
Oh, maybe not. I thought it was, we might have watched it on a different hearing, but I swear it was the bond hearing where they did that. Well, that's all, you guys. The complaint is in the description. There's also a playlist in the description with my old streams on this case and like the loose videos that we watched here if you want to watch any of those videos as a standalone. I think I set this video up to redirect to Broken Baker, who's starting with opening statements day 1 of the Dale Warner case. So that's the, oh, it's actually right here, coincidentally. So Broken Baker is watching this trial. It just started, so you won't miss anything. For Edric Faust, I don't know if there's going to be court tomorrow, so we'll have to keep playing that by ear. If there is no court for Edric Faust tomorrow, I plan to do the sentencing of Juliana Magalhaes from the au pair trial tomorrow. I think that's going to be early in the morning before I start the Faust streams anyway. But there's also Nathan Wade is supposed to sit in front of the Georgia Senate Committee on Special Investigations. He's got to testify under subpoena. So if there is no court for Faust tomorrow, we'll do like a Valentine's Day pregame tomorrow. We'll watch the au pair and we'll watch Nathan Wade. And anything else that you guys can think of that might be appropriate for that type of theme. Otherwise, I can't wait to see what's going on with Edric Faust. If you didn't see, if you're not over on X, I posted quick docket updates. So we had, it hit the docket today, even though it's dated the 26th day of January, but it's a subpoena for Brenda Swinney. So this is where we're going to hear about this interrogation. They interview her. Apparently, she used to beat on Faust, but she made a claim against him as well at some point. So I don't know if they're going to be able to talk about bad character for Faust. I don't think they'll be able to get into that. But she also, after being interviewed for quite a long time, eventually ended up saying to the detectives, according to opening statements, that God came to me and he showed me that Faust started a fire. He set a house on fire and he stole a television. So I would imagine that the subpoena is being renewed because the defense plans to call her. Also on the docket, you heard me mention that there was a notice of appeal and a motion to post a supersedious bond for the contempt order. There's an amended notice of appeal with a little bit more meat on it. They're just saying that they're appealing the contempt order, and that they want, transcripts of the hearing, transcripts of motions. So it seems like they're going to argue a lot more than the contempt oral order itself and the written order on their appeal of the contempt order, because they're looking for all these other orders that were denied previously on the docket. So just requesting stuff be transmitted to the Supreme Court of Georgia. So I'll be looking at that docket as well to see if anything comes up. And that's all I saw as far as updates over there. And Melanie, thank you for the super. Says there is so much more. Please cover this again. I am good friends with Mick. There are crazy things on this case. Are you on X, Mel? If you are, let's get connected over there. I believe I'm connected with Mick, and I'd be fine if he wants to come up and talk about anything he wants to get off his chest, even if it's another topic. It'd be kind of cool to have, like, Mahendra Patel's take on, like, a kind of similar situation. I don't know, I always think that would be cool. So whatever he'd want to talk about, I'll see if he wants to come on and chat. But Melanie, if there's something specific, like, hey, like, this is a crazy detail, it needs more attention, or I think it'd be interesting for you guys to talk about, let me know. But if we can do it on X, I can see it 24/7. If you guys don't, let's see. If you are on X, here's my X. And then Melanie, I really don't check my email often, but you can always, I'll probably get caught up this weekend on some behind things. I do have a general email just for like content purposes, take on trending, like what's your take on something trending at gmail.com. So I'm way slower with the emails than I am on X because I check X because X is quick with news, right? So I'm always checking. But yeah, that way you don't have to super or wait for me to have a video to let me know something. Sweet, let's get connected over there. All right, you guys, Dale Warner over with Broken Baker. Go say hey to Broken Baker if you want to watch that trial. He's a great place to watch trials. But at least say hey. He raids us a lot, and this is a chance for us to go and fill his chat with some cat raid. So hope to see you guys over there. I might pop on live later to talk about another civil rights lawsuit about a 75-year-old man who a child predator online in another state used a random fake number, just picked a random phone number when signing up for a meetup site where that man ultimately would talk to and try to solicit a 13-year-old girl or child. I don't know if it was a girl. The random number that that person in Michigan in another state chose to use ended up being the phone number registered to the 75-year-old man's wife. So investigators, they go, oh, this is the phone number he used to register this account. This woman's name is on it. This woman's associated with a man. That's her husband. Let's get an arrest warrant for him. And then he's arrested while he's in Niagara Falls on vacation with his wife and held for 13 days. They don't do any further vetting. So I think it's a little bit similar to what we're hearing here we don't go and investigate the obvious. We just have a phone number on a website that doesn't require verification of the phone number. And so I have that complaint, and I've been waiting to do a live when I had free time, and with no FOSS trial, maybe we'll do that later this evening. So if you guys want to tune in for that, hit the bell, and see you guys over at Broken Baker. Thank you guys.